Hi there, my name is Sandy Noakes and I'm the Director of First Year Studies and Community Engagement in the School of Law at Western Sydney University. Prior to becoming an academic, I worked in legal practice for many years as a labour and employment lawyer. At Western Sydney University, we really think it's important for our students to get practical experience in the law, and this starts from day one. Normally, one of the ways we do this is to make use of our moot courts at Campbelltown campus and Parramatta campus. These give our students the experience of presenting cases in a courtroom setting. However, in 2020, this has not been possible. So we have had to come up with some quite creative ways of giving our students those practical experiences. In criminal law, which is studied by our students in first semester of first year, our students are required to do a bail application. And as in courts all over Australia, we have required our students to use technology in 2020 to do their bail applications. So, what is bail? Well, when a person is charged with an offence, they can either be released on bail or they have to remain in custody. Certain offences, called show cause offences, are automatically denied bail due to the seriousness of the offence or because of the history of the alleged offender. The person charged can show cause why they should not be kept in custody. And they may, for example, advance reasons that their detention would have an adverse effect on them, for example, as an individual, or their family or community, or they might argue that it is grossly against the doctrine of the right to liberty. If a person can show cause, then the court then undertakes an assessment of whether there is a risk to the community for the person being released on bail, using a framework that's set out under the bail legislation. The bail applications that we'll show you today are hypothetical situations that we provide to our first year students. There are copies of these fact scenarios available for you to look at if you're interested. The students must sort through the facts and ascertain their relevance to ensure that their bail application is persuasive and to enable them to make the best case for granting bail for their client. They also have to do this in 5 minutes because, as in a real bail hearing, lawyers are given a limited amount of time to convince the court that their client should be granted bail. In this demonstration, I'll act as the judge, and some of our current first year students will present their applications to me. You'll see that I'll ask the students questions to clarify the main points that the students are providing to the court. These hypothetical situations that we give our students are also always designed with some wriggle room in them because we want to see students' ability to think on their feet, to answer questions that they might not be expecting, and to solve problems. If you come to Western Sydney Law School, and I sincerely hope that you do, then this is the type of practical assessment task that you will be doing with us in your first year of study.
Your Honour, the detention of Mr. Chambers is not justified for numerous reasons. My client has a lawful need to be at liberty to provide and care for his family. Mr. Chambers is the father of a 6-year-old who he cares for and lives with his partner. He works a full-time job in order to provide for his family, whom detention would have a detrimental effect on. Bail is required for my client to prepare his defence. Mr. Chambers was acting in self-defence at the time of the altercation, as the complainant, Mr. James, has admitted to police that he initiated the interaction and threatened my client. This, paired with there being no evidence of previous convictions or a violent nature, proves that his case is strong.
Can you tell me, do all of your proposed bail conditions comply with Section 20, capital A of the Bail Act, such as the requirement that they be proportionate, reasonable and not onerous on your client?
Yes, Your Honour, they do. Therefore, Mr. Chambers' strong case, compliance with bail conditions, ties to the community an essential need to provide for his family and participate in rehabilitation programs, proves that he poses no unacceptable risks and any bail concerns have been negated by their relevant release conditions.
Mr. Chambers has strong community ties and is employed full-time. His detention would restrict his income, which is supportive to his 6-year-old son and partner, and therefore his detention would significantly impact his family and local community. In regards to Mr. Chambers' previous charge, I submit that his detention would prohibit him attending his crucial weekly drug rehabilitation meetings. The current matter does involve a serious offence carrying a custodial sentence. However, I submit that the prosecution have a weak case, as Mr. Chambers believes that his conduct was necessary to defend himself, and will present self-defence at the trial as per section 418, subsection 2A of the Crimes Act. Further, I submit that Mr. Chambers has only one prior charge of alleged serious offence, which was driven by a drug dependency rather than criminal motives. I submit that this dependency has been resolved through ongoing rehabilitation, which retracts any likelihood for reoffending.
Yes, Mr. Putty, can I just ask you though, your client, Mr. Chambers, is on bail for a supply of a commercial quantity of heroin, isn't that right?
Yes, Your Honour, that is correct.
So would it follow that Mr. Chambers has possible ties to criminal organisations through which he obtained that commercial quantity, and that this could increase the risk of him committing a serious offence?
Your Honour, I submit that there is no evidence of Mr. Chambers having ties to any criminal organisations, as this would have been made apparent during the trial for his previous offence.
The court holds some serious concerns about this risk, I have to say, Mr. Puttick.
Your Honour, if the court holds concerns, then we can suggest a character acknowledgement from Ms. Small, the coach of Mr. Chambers' soccer team, or a conduct requirement.
I submit that holding Mrs. Jones on remand is not justified, Your Honour. Mrs. Jones has a child with special needs who she takes to regular doctor's appointments, as Mr. Jones runs his own small business and is not able to take their daughter himself.
Yes, Ms. Morgan, can I just interrupt you there for a minute though? I understand from the brief that Mrs. Jones's children are in fact regularly cared for by her parents and also her parents-in-law while she works. So I'm interested to know what is preventing them from attending their granddaughter's doctor's appointments.
Your Honour, a parent's management of their child's medical condition is paramount to their care and cannot be replicated by other members of the family. Mrs. Jones must attend in order to keep up to date with any possible prescriptions she must administer to her child, as well as any changes in care or treatment advised by the specialists. Mrs. Jones is actively involved in her children's school and attends a prayer ceremony every week at the school. Mrs. Jones' remand would therefore have a significant negative impact upon her 2 young children and the broader community.
In relation to endangering the safety of Mrs. Hands, the 2 individuals have strong connections as they own a business together and have grown it to be successful. Mrs. Jones submits she never intended to cause harm and was seeking a mediator's help. Therefore, I submit that there is no unacceptable risk in this matter.
Yes, Ms. Yousefi, I'm a little bit concerned. The accused and the victim have both given statements that they now cannot be in the same room as each other without arguing. And so you can probably understand that I have some concerns for the safety of the alleged victim here. What would you say to this, and what conditions would you suggest to the court in terms of bail conditions?
Yep, in such circumstances, perhaps a conduct requirement such as instructions not to approach Mrs. Hands could be adequate to successfully address this issue. Lastly, in addressing bail concern of interfering with witnesses or evidence, there were no other witnesses present where the conviction occurred, Your Honour. Since the event occurred, Mrs. Jones has been held in remand and she has not interfered with the evidence. With the acknowledgement of her background, she has never failed to withhold from the requirements that were imposed on her. In the matter that Your Honour is concerned in regarding to Mrs. Jones interfering with the evidence, perhaps the conduct requirement of retaining within 1 kilometre of the therapy business would effectively address this concern. Therefore, I suggest that there is no unacceptable risk in regard to this matter, Your Honour.
However, I submit that detention is not justified, Your Honour. In fact, Miss Nancy is a model member of society. She is a pensioner who has 5 grandchildren, all that depend on her care, and therefore any time spent in custody is of great detriment to these children. She is also a quality volunteer at her local food drive and has strong community ties. In addition, Miss Nancy has been extremely apologetic and has visited Miss Frazee in hospital on multiple occasions. I also highlight that at the time of the offence, Miss Nancy was unaware of Miss Frazee's bone condition and only meant to push her into the corridor. Therefore, there is a significant question regarding the specific intent to cause grievous bodily harm, which I respectfully deem to be a fault in the case of my learned friends. There also lies the issue of whether or not broken legs constitutes grievous bodily harm. Furthermore, bail not only infringes on the presumption of innocence, but my client's right to be at liberty. It is for these reasons that I deem detention is unnecessary on the balance of probabilities. In relation to failing to appear at proceedings, I submit that with a maximum penalty of 25 years imprisonment, Ms. Nancy will not do anything that will be of detriment to her case. In the past, she has also demonstrated exemplary behaviour in attempting community service, signifying her respect for the courts and law. However, I do admit that while on bail for her last offence, she failed to comply with one of the conditions. In saying this, it is her only instance of non-compliance with the courts, and therefore I deem that there is no unacceptable risk.